just going to do a very quick review. So the first day, I tried to help you understand what is the most important document in all of the American system of government, the system of law. This is the Declaration of Independence. It really is central to understanding the way in which things work in the United States, because it gives us our theory of rights and also tells us what government is supposed to be doing, right? And it's not as it is in other countries. The government is supposed to be limited in what it does. You remember that the Declaration says that because we're human beings, we are endowed by our Creator. Whatever is the reason that we exist as human beings, we all have rights. Now, not a right for anything, but things like life, to be alive, liberty, to be free, and pursuit of happiness, to be free, among other things, to find happiness with what makes you happy. But because there are sometimes conflicts among people and what they want to do in their lives, and because sometimes there are things outside of our country that interfere with our rights, we have a government. Government helps to secure rights. It helps to control our rights, to make sure that we don't interfere with each other and other people don't interfere with us. That government, as I said in the Declaration, is a government that comes from the people. The people are the sovereign in the United States. Now, this is said in many countries around the world. In the United States, it's really true. And I would say for better or for worse. Sometimes the people go crazy. They do crazy things. And as a result, the government will end up doing crazy things. Although the hope always is that the people who get elected, the people who that are designated by people generally to be in charge, will make sounder decisions. But it's not always the case. There are times when Americans go crazy. I'll give you a great example. So during World War II, when World War II broke out, as you may know, I mentioned this before, the Japanese people attacked the United States at a place called Pearl Harbor. Pearl Harbor was a port in Hawaii, Oahu, one of the islands in Hawaii, and Honolulu, it's very close to Honolulu, the city of Honolulu. Well, after that happened, the American people went crazy. They decided that anybody who was Japanese, who lived in America, even American citizens who were Japanese, were a threat. They were a threat, so they went crazy. And they made all of the Japanese people move away from California to live in special, they called them detention centers, but they were basically prisons where people couldn't leave. Why? Because they were Japanese. Everybody got so afraid of the Japanese that they did crazy things. And the leader of the United States, the President of the United States, Franklin Delano Roosevelt, agreed to this. Sometimes the American people go crazy, but the American people are in charge. They make decisions, and they really are the sovereign, and they have control, the people do, over almost everything that happens in government in one way or another. Okay, so that's the Declaration of Independence. We all have individual rights, right? The government is there to secure our rights from each other and from foreign enemies, right? And that government, although it has power, is a government that originates with the people. Now, the second day, yesterday, I know I was a little fatigued, but we were talking about what that government is. What is the government that was created to do that? And that is in the Constitution of the United States. The Constitution of the United States was the second try. The first try didn't work very well. The second try was the Constitution of the United States. It was written in 1787, and what it did is create a government designed to secure rights. Actually, if you take a look at the Constitution, there's something we call the Preamble. If you take a quick look at it, I can just read it to you because it's very short. The Preamble describes what the Constitution is supposed to do. It's right at the beginning. See, it says, "We the people." This is the Preamble. Right? The Preamble. Preamble. We the people of the United States. Who is making this government? The people are making this government. Nobody is imposing this. Nobody is telling everybody else they have to do this. This is what the people have decided to do. We, the people of the United States, in order to form a more perfect union. Remember, there was an earlier try. It was a flop. So they're trying to do it again in a more perfect way. By the way, nothing is perfect. So you notice it says more perfect. You know, can you really be more perfect? It's either perfect or it's not perfect, right? Well, what they're trying to say is this was a better try. In order to form a more perfect union, establish justice, so a principle of justice, right? Ensure domestic tranquility. This means peace in the country itself, right? In other words, people not attacking other people's rights, right? Ensure domestic tranquility. Provide for the common defense. That is to say, to protect us from those outside who might interfere with our rights. Promote the general welfare. Allow us to be prosperous. And secure the blessings of liberty. Allow us to be free, right? To ourselves and our posterity, right? That means to ourselves and all of our children and our children's children. And in Hebrew, we say lador lador, generation to generation, right? Do ordain and establish this Constitution for the United States of America. So the Constitution was created for those reasons, which are the very same, if you look carefully at them, the very same reasons that in the Declaration of Independence it says you have a government, right? To protect and secure rights inside and from outside, okay? The Constitution was that government. That Constitution, as I said yesterday, was based on several principles. One is it was a limited government. It was not a government for everything in the United States. At that time, the United States was not very big. There were only 13 states. It eventually got huge, right? Huge. But even when it was huge, the government is a limited government. Why? Because the people live within regions we call states. And the states are responsible for making the most important day-to-day decisions. The federal government, the national government, is the government that's consulted for the most important purposes. What purposes? The ones it states in the Preamble. Securing our rights, protecting us from each other, right, and also from our foreign enemies. So it's limited government, and it's a federal government. What does that mean? For some purposes, you know, I did this diagram yesterday. It's kind of a very crude diagram. But the federal government is here. The states are here. I'm not going to draw stick figures again, but you know, there are people here. And sometimes the government acts on these states. Sometimes it acts on the people. Right? Sometimes they act on the people. Sometimes if this and this conflict, then the federal government is the one that makes the decision. But it's a federal system. That is to say, there are two parallel systems. This is very important when we get to the courts, which we're going to do today. So it's a federal system. And this government has what's called the separation of powers, or checks and balances. Different activities are separated into different parts of the government, and each one of those parts has a check on the other. Each one has a check on the other, right? This is very interesting. So you may know the country, the Czech Republic, which was previously, when it was bigger, it was called Czechoslovakia. The man who founded Czechoslovakia was a man by the name of Thomas Masaryk. And he was an interesting fellow. He was a philosophy professor, going on a philosophy professor, in addition to being a lawyer and a politician. And he admired the American Constitution. So when he created Czechoslovakia, which he did with the help of the United States, he had a separation of powers. He had the legislature, he had the presidency, and he had a judiciary. But he believed it was so important to keep these separate, he actually put each one of them in a different city. So if you go to the Czech Republic now, while the legislature is in Prague, the capital city, the courts are primarily in another city called Brno. And because he thought it was so important to keep these separate. And as I said, each has a check on the other. So you cannot pass legislation in Congress without the president giving his okay, or her okay someday, right? Her okay, right? The president cannot have ministers unless the Congress agrees. And the courts, because of the decision I mentioned, Marbury versus Madison, have kind of the final say. Now, one question you might ask, might occur to you, what keeps the courts under control? How is the court checked? What is the balance against the court? And this is really the first thing that I'm going to talk about today, which I mentioned yesterday briefly, but I want to elaborate on. What keeps the courts under control? Now, one of the interesting things is that the judges in the courts, once they become a judge, they have to go through a nomination process that comes from the president, approved by the Congress. They then go on the court. But once they're on the court, they're there for life. The phrase we use in the Constitution is, during good behavior. But the only way they can be removed is through a very difficult process, similar to removing a president, called impeachment. Once they're on the court, they're there all the time. This is true of the federal government, not necessarily true of the states. I'll have more to say about that as we go along. But federal judges are judges for the rest of their lives. So what keeps them under control? You see, this is a very interesting problem that people don't think about. Actually, one of my daughters is now working on this. She's an historian, and she's studying this kind of problem. What keeps the judges under control? Well, the founders talk about this quite a bit. And they decided that judges were not very dangerous. The reason they're not very dangerous is not that they couldn't make important decisions. It's what they could make decisions about. First, remember, it's only those things that are about the federal government. So it's already limited. But there's a second thing that kept judges from doing things that had a huge significance. And this is what I called yesterday the case or controversy requirement. There has to be an actual dispute between two parties that really care about the outcome. And when the judges make the decision, sometimes with a jury, as we'll talk about later today, They're making a decision only about that controversy. It's narrow. It's narrow in the subject matter that can come before the court, and the decision is only about that controversy. They don't make decisions on hypothetical questions. They don't make decisions on general questions. Their decision is about the actual dispute, and there has to be an actual dispute, the actual dispute between two parties, sometimes the government and a private party, sometimes two private parties, only about that matter. And the people who wrote the Constitution said, because judges are so limited in what they can do, both in subject matter and in terms of the actual controversy. These are very famous words in the United States. They are the least dangerous branch. You don't need to check them as much as you need to check the president, who has all the power. He's the commander-in-chief of the army. You don't need as big a check because, like you do with Congress, because Congress can pass a law that affects everybody. No, a judge can only decide on certain individual controversies and only about the controversy in front of him. Now, that's the theory. What happens in practice? Well, over the last 236 years, if I'm going to remember now, right? Over the last 236 years, judges have more and more expressed their views far beyond the controversy in front of them. Once you are making decisions, it's very tempting to be able to make a decision which has a large number of consequences. So, although judges may have needed less of a check originally, because this was so narrow, right, and because they could only decide on a case or controversy, over time, judges have gained much greater power. And of course, this expanded as well. So the subject matter expanded. Now, in some ways, the Supreme Court is the most powerful part of our government. Not in all ways, but in some ways. It was regarded as something that you didn't have to worry about. Now, if you're really interested in what happens in the United States, you always have to think about the Supreme Court, because they have the final word. And this has sometimes been extremely important. In 2000, we had an election that was incredibly close. You know, we had 160 million people voting. Maybe it's only 130 million people back then. But we had a huge number of people, and it was really close. And it came down to literally hundreds of votes in the state of Florida. And there was a big controversy about these votes. How should these votes be counted, or whether they should be counted or not counted? There were all kinds of problems. Who made the decision? The United States Supreme Court, in a case called Bush versus Gore. Those were the two candidates. Remember, you have the national controversy. The two candidates, George W. Bush and Al Gore. And it came down to a few hundred votes. Should these votes be counted? Should these votes not be counted? Who made the decision? The United States Supreme Court. If you follow what's happening in the United States now, there are big controversies about things that Donald Trump did, both while he was president and immediately after he was president. Those controversies are in the courts. Why? Because it's Donald Trump versus the United States, or Donald Trump versus individual parties or whatever. Ultimately, these are going to make their way to the Supreme Court. And when the Supreme Court makes a statement, that's going to decide the issue. You see, the Supreme Court has enormous power, really enormous power now, far beyond what I think the founders anticipated Because remember, they thought this was going to be very small, and it grew and grew and grew, and that the case and controversy requirement would keep everything narrow. Well, this got very big, and the case and controversy requirement got expanded, stretched, so that the Supreme Court, the courts of the United States, and the Supreme Court had very, very, very great power. Okay, that case and controversy requirement, as I mentioned, is part of the heritage of the common law. The common law always worked this way. You have to have an actual dispute. If you don't have a real dispute, the courts should not be involved. This is a sign that the Constitution, without actually stating it, adopts the common law. Right? The common law is made part of how the courts operate, without anybody even saying it. And the reason is this was so much a part of the history of the people who lived in the colonies, they never even thought to question it. There are going to be courts. Courts are going to operate like common law courts, right? Common law courts. Now, I keep using this word common law. I explained to you where that term comes from. But the common law is unusual. It's unusual because it depends upon a way of deciding things that is itself unusual. And I will explain that. We call that the adversary system. The adversary system, which we use in our courts as part of our common law heritage, is an unusual way to make decisions. So the second thing I'm going to do today, after I talk more about the courts, is talk about the adversary system. And you'll see why it's different. It really is different. It's interesting, American lawyers don't understand that it's different. American lawyers think everybody does things this way. It's exactly the reverse. Most people do not use the adversary system. In America, we use the adversary system, and I won't be able to explain all of it to you, and some of it will be a little theoretical and hard to understand, right? But I'll try to give you a kind of a basic understanding of what's going on, okay? The third thing I'm going to talk about today are juries. This is very interesting to me. So, if you look at Article 3, and actually also elsewhere in the Constitution, you will see references to juries all the time. Now, this is a word that has a particular meaning in the common law system. It's another indication in the Constitution that the common law has become part of the judicial process. There's a reference to juries. These juries, I learned this yesterday, these juries are not like the juries you have in a Vietnamese court. Right? In the Vietnamese court, you have the judge and two jurors, two people's juries. Isn't that what they're called? On either side. It's not like that. Totally different. And when you see the difference, you'll understand. The people who serve on juries, I mentioned this yesterday, are you and me. Ordinary citizens sit on juries. And everybody who votes also has an obligation to serve on juries. How often does this happen? Maybe once, twice, 3 times in your life. You are summoned to maybe sit on a jury. It doesn't happen very often. Why? There's so many people. Right? And we don't need that many people for juries. But the juries we're referring to are a very distinctive feature of American law. Now, we got this from the British, right? The British will also use juries. But I will say that in America, it's kind of gotten its own characteristic, juries. They are, in my opinion, and this is a minority opinion, one of the greatest inventions that has ever existed. It's incredible. And it is incredible because it is part of how in America you're free. And I will show you why I think this is the case. Many people, even in America, I would say even most people in America, think juries are kind of nutty. They really do. They think it's nutty. Why? Well, maybe for the same reason that some of you think it's nutty. Why should you let ordinary people make decisions about lawsuits or prosecutions? Why should you do that? You're not, well, some of you are now, but ordinary people are not trained in the law, right? They don't have any special expertise. Why would you let ordinary people make decisions that have such great consequences? Well, you'll see it's not that simple. And when you understand how the system works, it makes perfect sense. But most people, I would say even in the United States, don't quite understand how the system works. When you study the system, what you learn is that juries do a really good job with most things. Do they make mistakes? Of course they make mistakes. Of course they make mistakes. Who doesn't make mistakes? Right? But because of the way they're constructed, it's not that they don't make mistakes. It's that in some instances, with respect to some matters, everyday matters, they make fewer mistakes. Do they make mistakes? Absolutely. I'll tell you some cases in which they made mistakes. Sometimes very funny. They make mistakes. The question isn't whether they make mistakes. The question is, do they make more mistakes? Right? And what do we do to try to avoid those mistakes? It's very interesting. Okay, so those are our three topics today. The court system itself, the adversary system, which is part of the court workings, and the jury system, which is a big part of American law. Okay, let me talk a little bit about the courts themselves. What kind of courts do we have? Well, the first thing you should keep in mind is that we have federal courts and we have state courts. Every state has its own court system. So I live in the state of Illinois. Illinois is in the middle of, remember the first day I pointed where it was? Illinois is in the sort of the middle of the country. It's in what we call the Midwest, right? And it's a state that's shaped like this, you know. And Chicago is up in one corner. It's the biggest city in Illinois. Illinois has its own constitution, has its own legislature, has its own executive. We call him a governor. We've never had a female governor. You know, someday we'll learn. Someday we'll do this properly. Right? You know, I've been saying, maybe I said it yesterday, I can't remember. Right? You know, we've been letting the men make the decisions for thousands of years. Maybe it's time for the women to be making decisions. The men haven't done so well. Right? It's time for the women to be making decisions. But anyway, we have a legislature in Illinois, we have a governor in Illinois, and we have a court system in Illinois. The court system in Illinois is pretty typical in many respects of court systems in the other states as well. There are some variations. There is a trial court. In Illinois, this has the name circuit court. Let me just say that things don't always go very well in the circuit court. The judges are not the best judges. The activities are sometimes very chaotic. So sometimes we joke and call this circus court. You know circus? Lawyers do this. They call this circus court. Why? Because it's a big circus, right? Things tend to be very chaotic. right? As I said, the judges are usually not the best judges. They're not the best trained. They haven't been sort of selected, and they don't always have the most experience. Above the trial court, very similar to yours, we have the appellate court. This is very typical, state by state. An appellate court. It's divided into various sections, but it's an appellate court. Every case that's heard here, you have an automatic right to appeal to here. Okay? If you don't like the outcome here, you can appeal here. When you do appeal, you don't get to provide the evidence. You work with the record that exists here. This is pretty typical. I think in your, here you call this the provincial court, am I right about that? But it's an appellate court. Above that is the Supreme Court. Now this is not the Supreme Court of the United States. This is the Supreme Court of Illinois. So you have an automatic right to appeal to here. You do not have an automatic right to appeal here. You have to request the court to hear the case. And the court ordinarily hears only a very small number of cases that they think are particularly important. Okay? This is the basic structure. So if you now move to the federal court, what you have a trial court. In the federal court system, we call this district court. You have an automatic right of appeal to the Court of Appeals. There are 12 different courts of appeals based on the region of the country. Illinois is in the 7th circuit, the 7th region. So region number 1 is New England, basically, off in the northeast. Region number 2 is New York and New Jersey. Region number 3 is Pennsylvania, Maryland, Delaware. Region number 4, Virginia, North Carolina, South Carolina, and so on and so forth. Illinois is the 7th region, the 7th circuit. The reason it's called a circuit is hard to explain, but it's the 7th circuit, and in the 7th circuit or region is Illinois, Indiana, and Wisconsin. The largest of these is called the 9th circuit. The 9th circuit includes Alaska, Hawaii, California, Washington, Oregon, Nevada, Arizona, and I think Idaho's not. I think that's all. Right? It's very large. Right? What decides where you go is what state you're coming from. So if you have a case that is in the federal court in Illinois, because there is a federal court for Illinois, even though it's a federal court, right? You go to the 7th circuit. From the 7th circuit, you would go, from every circuit, you go to the U.S. Supreme Court. Just like what I said about Illinois, in this court, you get to try the case. In this court, you have a right of appeal. Any case that gets decided here, you can appeal here. But you cannot, by right, go to the Supreme Court, except in a very few cases. The Supreme Court the United States Supreme Court gets to hear those cases it wants to hear. It usually hears about 80 cases a year. How many cases are there down here in the United States? Tens of thousands. By the time you get up here, maybe 80 are heard in any particular year. Okay? So it's a process like that. Every case down here can be taken here, but here you have to do what's called, you file what's called a writ of certiorari. This is just an old-fashioned name for a request to have your case heard. Okay? So notice how similar they are. Very similar. This is for those matters that happen in the states. This is for those issues, even which happen within the states, which happen anywhere, having to do with the subject matter of the Constitution or the United States, or the laws made under the United States. Important rule. Remember I mentioned this before. If you have a disagreement between what happens here and what happens here, which wins? Which wins? Right? You've got something that happens in the state where the states make a law or the states make a decision, and you have a different decision or a different law in the United States. Which law wins? You can tell me. The United States, because of what I call the supremacy clause, all right? The rules of the Constitution and the rules made by the federal government are, as it says in the Constitution, the supreme law of the land. I believe that's Article 4, Section 4, I'm not positive. Right? The supreme law of the land. But, this is really important. While you're making your way here, this court cannot interfere. You've got to go through this whole process. And then, if you've gone through the process and you think that the federal Constitution would require a different result, you have to go here. So you've got to go through this process, and then if you think that the Constitution or the laws under the Constitution have been violated, you have to wait and go here. And this is by request. The Supreme Court doesn't have to hear it. Okay? But notice again how powerful the Supreme Court is. Right? The Supreme Court is the ultimate decision maker under the Constitution and is the ultimate decision maker with respect to cases that arise, either in the state or in the federal courts. You see? This is the basic court structure. A couple of other things I'll mention in passing, and then there's one thing I have to talk about in great detail. In Illinois, the judges who are here and here and here are elected. They are not appointed. They are elected by the people. It's very unusual. It's not true in every state. But they are elected. They actually have to run for office. Say, I'm a judge. I will do a good job. Right? And of course, people say, well, okay, suppose you got a case like this. What would your decision be? Oh, I can't say. Well, I am a judge. I have to be fair. Right? It's very odd to be in politics at the same time as you're a judge. Right? And this is always a little bit of controversy. In this court, every judge is nominated by the President of the United States and approved by the Senate. Not by the House of Representatives, only by the Senate. And as I said, once they're appointed, they serve for life. These people have to run for office on a regular basis, although the process changes as time goes on. But it's a very big difference between the two. Okay, are there any questions about this? This is the basic structure of the courts. Now, let me give you some interesting facts about myself as a lawyer. So I became a lawyer in Illinois. And by becoming a lawyer in Illinois, I can go into any one of these courts. I also could apply and was accepted to be in any one of these courts. So all the way up. Although you have to apply at each level. So I am actually a lawyer who can appear here, can appear here, and can appear here. I appeared in the U.S. Supreme Court, though unfortunately I never argued a case there. I had a case there, a very famous case actually, I was involved in, right? But I was not the person who got to make the argument to the court. It's really impressive to sit in the Supreme Court chamber. And I am what's called a member of the bar of the United States Supreme Court. And I filed many cases there. Of course, some of them have been accepted, some of them have not been accepted, but I've never gotten to argue there, probably never will. It's very rare for people to get to argue in the U.S. Supreme Court. Interestingly enough, if I have a case in, let's say, California, I'm not allowed to go into the California court. The state court. The state court. Until I make a special application with the California lawyer as my sponsor. I am not allowed to just walk into a California court like I can walk into an Illinois court. Okay? Each state has its own roster of lawyers. All lawyers in a state can appear in district courts, the federal courts. But not all lawyers in this state can go to another state. It's very interesting. You see, the states still have a lot of power. And they have their own jurisdiction. And they have their own roster of lawyers. I am also on the roster of lawyers admitted to the bar in the state of New York. So I can go into any New York court, right? But I cannot go into a Nebraska court. I cannot go into a Florida court, right? I can go into any Illinois court, any New York court, or any federal court. But I cannot go into another state court besides those two states. Now, will they let me in? Usually. Usually, unless I've done something really bad, right? They will let me in. But I have to make a special application. And if I'm accepted, it's only for that case, right? It's not for all cases. It's only for that individual case. You see, the federal courts are for the whole country. And so if you're a lawyer in any part of the country, you can go into the federal courts. The state courts are for the individual state. So unless you're a member of the special roster in that state, you can't go into the state courts. Now, as I said, you usually can do it if you get someone to sponsor you, but you get admitted not generally, but for the individual case you're involved with. There's a Latin phrase we use, pro hoc vice. It's actually pro hoc vice is in Latin. It means for this controversy. For this particular, that's all you get admitted for. By the way, to get into the Supreme Court, you can do it, but it's not easy. You have to find somebody who is a member of the bar to sponsor you. You have to be reviewed by the United States Supreme Court. I'm very proud to be a member of the bar of the United States Supreme Court. Okay, now one of the things I want to emphasize, and this is extremely important, is the difference between criminal and civil cases. Criminal and civil cases. Now this is pretty easy in the first instance. A criminal case, somebody broke the law, or at least is accused of breaking the law. Okay? That's what a criminal case is. A criminal case is when somebody is accused of breaking the law. I don't mean custom. I mean the official laws of the United States or of an individual state. That's a criminal case. All other cases are civil cases. Civil cases. In those cases, the government has no interest. No interest. Unless it's one of the parties to the dispute. unless you're suing the government or the government is suing you, not for breaking the law, but because you had a contract, you did something that under civil practice was inappropriate. Most cases in civil court have nothing to do with the government, and the government has no role of any kind. Okay? Most of what I do as a civil matter. I'm very rarely involved in criminal cases. Criminal cases require special expertise, right? Why? Because somebody's life or liberty is at stake. We take this very seriously, okay? So there's a difference between two types of cases. Criminal cases in which the government is involved. Civil cases in which the government usually is not involved. And in most civil cases, the government never makes an appearance or has anything to do with it. I'll give you some examples. You'll like this example. So last year, 2022, I was involved in a case where I represented Tiffany. You know Tiffany? Makes jewelry, Tiffany, right? Who sued them? Cartier. So Cartier filed a lawsuit against Tiffany in the state of New York. I'm a New York lawyer, and I was asked by Tiffany to represent it against Cartier. At no time in this case, which went on for a year, at no time did the government have any role of any kind, except of course with the judge, right? Because it was filed in court. No government prosecutor, no government representative. This was a private matter between Tiffany and Cartier. Now, when I say private, it was not so private. It was written up in the newspaper. And one of the interesting things in the United States is that there is a presumption that every case is open and public. So when we file things in the case, documents in the case, anybody can read them. Anybody. All you have to do is type it in. You have to have an account. You don't pay for it, right? You type in an account. You can read every document in the case. Every document, right? Just as an ordinary citizen or as a member of the press. You were entitled to read it. And this is generally true in most civil cases in the United States. We sometimes have stricter rules in criminal cases because somebody's reputation and life and liberty is at stake. And we want to protect people who are accused of a crime. Okay. So, civil cases, criminal cases. Now here's the difference between the state system and the federal system. In the Illinois state system, two different sets of courts. Criminal courts, civil courts. In the federal system, one court handles both criminal matters and civil matters. The same judges that hear the civil matters hear the criminal matters. There's an interesting thing in the United States. So if you look in the Constitution of Bill of Rights, you're guaranteed a speedy trial. And we have something in the United States called the Speedy Trial Act, which means that if you've been accused of a crime, you have the right to a very fast consideration. Because there are so many criminal cases, the judges sometimes don't have time to do the civil cases. And some courts are particularly backlogged, they're particularly jammed, because they happen to be in areas where there are lots of crimes. I'll give you an example. I represent Louis Vuitton in a dispute with some of its former employees. Actually, they're former employees of Saks Fifth Avenue. But we're in an area of New York, which is where all the airports are. In the United States, we have lots of cases of smuggling, which is a violation of law. All of those smuggling cases go to this court. And because the court is so busy handling speedy trials involving smuggling, it doesn't have enough time to do the civil cases. So you wait, and you wait, and you wait, sometimes years for things to get decided. Okay? But in Illinois State Court, there are criminal courts and civil courts. In federal court, one court handles both criminal matters and civil matters. Okay? I have a good friend. He is a federal judge in Buffalo, New York. So if you know New York, shapes kind of like this. Shapes sort of like this. Buffalo is here, right? And he is a federal judge at this level, at the district court level, right? In Buffalo, New York. That happens to be where he sits. He's a federal judge, but his courthouse is here. He's actually in the courthouse named after a very famous judge in the United States, right? And one day I was sitting talking with him. He's a friend of mine, and he was telling me all the cases that he had in front of him. And some of them were criminal cases. You may have heard some time ago that there was a terrible shooting in Buffalo in a grocery store. A man walked into a grocery store and just started shooting people, right? Well, a lot of criminal stuff came out of that. He handles all of that, right? But then he was telling me about some of the civil cases he had. And, parties dispute. Oh, this party was here, this party sued this party. It's very interesting. Okay, now I want to talk about the difference between criminal cases and civil cases, because it's extremely important. Do you want me to leave this on the board, or do you all have enough information? Sorry.
You should wipe it.
Yeah, I feel get away with it down? Yeah? Okay. I want to talk about criminal cases and civil cases, and particularly about criminal cases, because it's a very interesting feature of American law. So let's assume that you are accused of a crime. Somebody says you stole something. Right? That is a criminal case, and that is a case in which the government is involved. It could be the government of the state, it could be the government of the country, it could be the government of the city. That's a criminal matter. You're accused of breaking the law. Now, the first thing you should recognize about this is that it's unfair. Why is it unfair? The government is big, powerful, rich, right? And it has enormous resources to try to prove that you committed the crime. It has incredible power over you. Why? Because you're just an ordinary citizen. And even if you have a good business or a good job, you don't have anywhere near the money that the government has. You don't have anywhere near the power. You don't have anywhere near the influence. The common law and American law is very sensitive to this. Extremely sensitive. Why? Remember the rights. Life, liberty, and the pursuit of happiness. You have your own life. You are free to live your life, and you can pursue your life any way you want, right? And we are very concerned about you having your rights. And we are aware that people get accused sometimes of things they didn't do, and it's not a fair fight. The government is big and strong and powerful, and you are weak and not rich and have nowhere near the same kind of what we call clout, right? Power. This is a very, very interesting problem because you don't want people to be deprived of their life, their liberty, or their pursuit of happiness unless they really committed the crime. We're very sensitive to this, and therefore, in criminal cases, we have very special rules to try to protect people who commit crimes, or more importantly, are accused of committing crimes. We have a general rule. The general rule is sometimes stated like this: it is better for 9 guilty people to go free than 1 innocent person be convicted. We do everything we can, at least in theory. I'll talk about the ways in which this doesn't necessarily work in practice. We do everything we can to protect people accused of a crime, to make sure that before they're convicted, they are actually guilty. Okay? Now, what do we do? The first and most important thing we do is we say they may not be convicted unless it is proved beyond a reasonable doubt. Now you think about that standard for just a second. That is a very, very demanding standard. If there is any reasonable doubt, you cannot be convicted. Wow, pretty amazing, right? Pretty amazing. Beyond a reasonable doubt. Now, just so you have an idea, in a civil case, the decision is made by what we call a preponderance. More evidence this way than this way, this side wins. This side wins. This is a much stricter standard, right? To convict somebody, you need this much evidence, right? Beyond a reasonable doubt. I mean, this is just a graphic. But beyond a reasonable doubt, there has to be so much evidence that nobody could ever doubt a reasonable doubt. So I'll give you a great example of how important this is. Maybe some of you have heard of O.J. Simpson. O.J. Simpson was a famous football player in the United States. After he retired from football, American football, right? He was a very famous runner, and he carried the football. He was very, very good. After he retired, he married a very beautiful woman, and one day they found her dead. Her throat had been slashed. And they said, O.J. Simpson did it. O.J. Simpson did it. They accused him of a crime. There was a huge amount of evidence that he had done this. Huge amount of evidence. He was represented by a lawyer named Robert Shapiro, not me. That's very funny. When this was happening, my children came home from school and said, "Dad, are you representing O.J. Simpson?" I said, "No, I'm not." And you know, this is a very famous case in the United States. People who meet me ask me, did you represent O.J. Simpson? I said, no, it's a different Robert Shapiro. But it's very funny. It's led to some very funny events in my life. It's one of the funniest things. Anyway, there was a huge amount of evidence that he had committed the crime. And he was found not guilty. Why? Because even though there was a huge amount of evidence, it wasn't beyond a reasonable doubt. Later, under some special rules, the family of his wife filed a civil lawsuit against him, claiming what we call wrongful death. Government had no involvement with this. The family sued O.J. Simpson. It was a civil matter. Different standard. Guess what happened? They won. They won. They demanded money from him. By the way, he didn't have enough money. And he didn't really end up paying most of it. He didn't have enough money, but they won. You see, the standard made all the difference. Right? He was not found guilty. He did not go to prison. Not for that. He went to prison for something else. Right? Not for that. But he was ultimately found liable. Is what we say. Not guilty, but liable. Now, even this is a little misleading. I'm going to show you why in a second. Okay? Big difference. So if you're accused of a crime, you have to have this much evidence against you. This is not enough. Okay? Now, that's only the first thing we do. We do many other things too. I'm just going to give you a few of them. We said it yesterday. What do the cops, police say when they arrest you? It's the first thing they say. You have the right to remain silent. Look at the, I think it's the 5th Amendment, 6th Amendment. It says you have a privilege against self-incrimination. You don't have to say anything. The police can ask you questions for hours and hours and hours. They can threaten you, right? But by the way, if they do, they probably are not going to be able to use the evidence. You are entitled to remain silent, right? It's called the privilege . By the way, they go on to warn you that if you say something, that could harm you. So they basically tell you to stay quiet, right? You have the right to remain silent. Anything you say can and will be used against you in a court of law, right? Be quiet! Don't say anything, right? Why? They'll use it against you, right? So don't, and they can't make you. If they force you to confess, if they pressure you, if they, torture, anything like that, the judge will throw it out. It cannot be used as evidence. It cannot be used as evidence. Why? Because you are not required to say anything. This leads to a very interesting thing in criminal cases, which I'll talk about in a little bit. Okay? Another thing, you get a lawyer. That's the next thing they say, right? You are entitled to a lawyer. If you cannot afford a lawyer, one will be appointed for you. Everybody is entitled to a lawyer. You can refuse to use a lawyer if you want, but the judge will say, listen, you need a lawyer. Right? I don't want a lawyer. Listen to me. You need a lawyer. By the way, the judge is right. You should always have a lawyer. We have special people in the United States who are called, in the federal system, federal defenders. They are people whose only job is to represent people who can't afford a lawyer. Right? Everybody is entitled to a lawyer. There are many other elements of this that I don't have time to go through. We create huge numbers of protections for people accused of a crime. By the way, another thing is in every criminal case, you are entitled to a jury. And when I explain to you the jury system, you'll see why this is really important. Who's on the jury? You! You're on the jury, right? You're the people who decide whether the government gets to put you in prison, right? It's up to you, ordinary people. You get the opportunity to hear the evidence. Is it beyond a reasonable doubt? Your doubt, right? Did the person have the ability to keep quiet, right? If they wanted to, right? Did they have a good lawyer, right? You, the jury. And in a criminal case, there are 12 jurors, and it has to be unanimous. If only one of the 12 thinks that you shouldn't be convicted, you are not convicted. Right? You can argue for weeks, right? And the rest of the juror, the other 11 jurors can come in and say, you're wrong, he did it, right? If you don't think he did it, you are entitled to hold out to the very end. There's actually a very famous movie in America called 12 Angry Men, about a jury in which there was one juror who held out, who was unhappy, did not think there was evidence beyond a reasonable doubt. All the other jurors wanted to go home, right? They kept saying, you're wrong, you're wrong, you're wrong, you're wrong. And he said, I'm right. And that person was not convicted. So that's another thing we do. There are lots of other rules which all work to the advantage of the defendant. Why? Remember the principle. We want 9 guilty people to go free rather than have one innocent person convicted. We really tilt the scales. Now, there's a very important consequence of these rules that I need to show you. You get accused of a crime. You go into court to have your trial. The lawyers show up. There is a lawyer for the government, and there is a lawyer for you. The government gets to go first. Here is our evidence. Here is our evidence that this person committed a crime. What does the defendant have to do then? Absolutely nothing. Remember? They don't have to say anything. Right? They have a lawyer. The lawyer can say, not going to say something. And leave it to the jury. Now, why would you do that? Why would you do that? Here's the answer. This. What you do is you sit there and you say, nice evidence, but not beyond a reasonable doubt. There is still doubt. And then the lawyer will explain to the jury why there's doubt. You don't have to say anything. When the government is done, if you don't want to, you can just sit there. They didn't prove it. They didn't prove it. They have to prove it beyond a reasonable doubt. And there's doubt, right? And it's reasonable doubt. So I should go free. And this happens in huge numbers of cases. Why? Because it's difficult for the government to gather good evidence, right? And many times, people accused will just sit there and never say a word. They're not obligated to. They're not even obligated to bring other people in. They can just say the government didn't prove it. So remember I wrote this up here? A criminal case does not determine whether you're guilty or innocent. It proves whether you are guilty or they haven't proved you're guilty. Right? It's not a determination of whether you're innocent. It's a determination whether the government had enough evidence to prove that you're guilty. You don't have to prove you're innocent, right? All you have to prove is the government didn't prove you did it. This is so interesting. It's very, very interesting. Now, there are lots of other elements of this. When I talk about the jury system, you'll see why it's hard sometimes for the government to prove things, right? Because of the special rules we have for juries, right? So in addition to what I've already listed here, there are many other things too that protect criminal defendants. It is not easy to convict people in a trial in the United States. And again, the reason is we don't want to take away somebody's life or liberty or pursuit of happiness unless the government, which is big and strong and powerful, has really proved its case. There's a famous case that happened last year. It's very interesting. A man was accused of killing his wife and son. And he was a famous prosecutor. He was a guy who had put other people in jail through trials. He was very famous and very, very capable. He was a very distinguished trial lawyer. But he was accused of killing his wife and son. So they brought the case against him, and there was a trial, and they brought in all the evidence. Nobody had seen it. They did not find any weapon, right? It wasn't even clear exactly where he was. It was a textbook case of where the government might have failed to prove it beyond a reasonable doubt, right? But he got convicted, and here's why. He thought he knew how to handle juries. So he waived his right against self-incrimination and got on the witness stand to testify. And the jury listened to him. And they said, this man is a liar. They could tell from his own words, denying that he ever did anything, that he was not telling the truth. If he had just shut up, he probably would not have been convicted. But because he decided to testify in his part of the case, he was convicted. Fascinating case. It was fascinating. For a lawyer like me, I was absolutely riveted to this case. I was watching everything that happened in this case. The fellow's name is Murdaugh, M-U-R-D-A-G-H. He's now got an appeal. Remember, you can appeal? Right? He's got an appeal because he has some reason to believe that one of the jurors was prejudiced against him and didn't disclose his prejudice. So the Court of Appeals is now considering whether he got a fair trial. But he made a terrible mistake. I actually had an interesting experience with this. So when he was convicted, I wrote a text to my wife, an SMS. I wrote to my wife and I said, it was his own testimony that is responsible for this. And my wife wrote back to me and she said, no, what's responsible for this is he killed his wife and son. Which is a very good lesson for me, right? He did it, and it was clear to everybody once he testified. He was a liar, and everybody could tell he was a liar. One of the things that happens is when you're on the witness stand, juries are very good at sniffing out lies. You know, this doesn't sound right. Lying. They're ordinary people with good common sense, right? And they can tell. You can tell sometimes when people are lying. And when you have 12 people all watching very carefully, it's often possible to tell that somebody is lying. It's a fascinating system. It really is. Now, I've given you how it's supposed to work. It doesn't always work this way. Yeah, I'm sorry. It doesn't always work this way. Why not? Well, in the United States, we have lots of people who commit crimes. Lots of people who commit crimes. Trials are very expensive. They take a lot of time and a lot of resources. In addition, many of the people who commit the crimes, or who are accused of committing crimes, did commit the crimes. The police are pretty good at figuring out who did it, who didn't do it. Not in every case, but there are lots of times people are arrested justifiably, right? They get arrested. So what happens? Instead of going through a long trial where the outcome is going to be a certain way, the government lawyer and the lawyer for the accused person get together and make a deal. Right? Do you know about this? This is called, you know what it's called? It's called a plea bargain. A plea bargain. So the government lawyer will go to the accused's lawyer and say, look, here is all of our evidence. Here's all of our evidence. Your guy is going to get convicted. Spare us the trouble. And if you do, we will reduce the charges. Right? So maybe instead of going to prison for 50 years, we'll go to prison for 5 years. Okay? They make a deal. The problem with this is that there's enormous pressure on people accused to give in to a deal. I'll tell you a story about this. One time I got a call from a fellow, actually the court asked me to do this, I forgot. The court asked me to represent somebody who had been found with, gone to prison after a plea bargain. He made a deal. He had gone to prison for 10 years. He was in about year 6. And he had filed a special action, and the court asked me to represent him. So, of course, the first thing I did was go to meet my client. He was in prison. I went to meet him in prison, and I interviewed him. I said, well, tell me about this. He said to me, I didn't do it. I said to myself, all right, you made a deal, you agreed you did it. What do you mean you didn't do it? Anybody ever seen the movie The Shawshank Redemption? There's a great moment in this movie where Tim Robbins, who's new in the prison, goes to a longtime prisoner and says, you know, that guy didn't do it. And Morgan Freeman is the old-time prisoner. And he starts laughing. He says, if you ask everybody in here, they didn't do it. And I've actually had this experience. I've represented many, many people who clearly committed crimes, right? And they will all tell me they didn't do it. I mean, it's very weird. It's kind of a psychological thing. So he says to me, I didn't do it. I said to myself, sure, okay. He said, the people who accused me made it up. I said, please. And he said, no, I'm telling you they made it up. Now, what was he accused of? He was accused of breaking into the apartment of his girlfriend, who lived with her mother, in order to beat her up. And he was accused of breaking down the door. And he made a deal where instead of going to prison, maybe even for life, he would only be in prison for 10 years. It's a long time to be in prison, right? And he made this deal. And he said, I didn't do it. I said, please. He said, look, you go talk to my former girlfriend, her mother, and the next door neighbor. I guarantee you, they will tell you I didn't do it. I said, they filed statements that said that you did it. He said, they were all lying, and you can get them to acknowledge that they were lying. So I rolled my eyes again. I said, this is crazy, right? But I did it. I went off and I interviewed the girlfriend, the mother, and the next door neighbor. They all said to me, he didn't do it. I went, what? He didn't do it. I said, but you filed statements that said he did. Yeah, we were trying to get rid of him. We knew if we filed these statements, the police would arrest him, then he would make a deal and he would go to prison. We want to try and get rid of them. And this was really, I was so amazed. And then I went back to him and I said, well, why did you make a deal? Why did you make a deal? If you knew that you didn't do it, if you knew that they were lying, if they were ultimately willing to admit that they were lying, why did you make the deal? He said, I didn't think I had a chance. I thought the government would bring them in, they would continue to lie, right? And I would never stand a chance. Three women against me, I would never stand a chance. This was really interesting. And it was a great example to me of, although the theory is everybody gets a fair trial and there's a high standard or whatever, that many times, particularly people that are poor, he was also African American, people who are poor don't think they have the ability to resist the state, the government. And so they make a deal so he could go to prison for 10 years rather than for the rest of his life. It was fascinating to me. And it was a very great practical example of sometimes how the system doesn't work the way you expect. Because there are plea bargains every day, hundreds of them. Some of these people definitely did it. But sometimes people get caught up in the system where they decide, I better make a deal because even though I'm innocent, I didn't do it, I don't stand a chance in court. It shouldn't be that way, but it is. So, by the way, I was able to get him out of prison, but it took me about a year to do it because there are rules in the United States about how soon you have to make complaints like this, and this is, maybe it was only 4 years that got by, but it took me a long time, but I ultimately got him out of prison. It was a fascinating case. It was very gratifying. When he walked out of the prison, it was a very nice day. It was a very happy day, because this is a man who had been in prison unlawfully. You may know that in the United States, there are many people on death row. In some states, we still have capital punishment. They're on death row, and at the last minute, they can prove to be innocent, and one of them are proved not guilty. And one of the things that's been very important is DNA evidence. DNA evidence. So many times, people are accused of murder and rape, and they have DNA, right? Sometimes from the attempted rape, sometimes from other things, and they can use the DNA, and if the DNA doesn't match, then you know he couldn't have done it, right? And this has become a very big thing in the United States. Why? We set up a system to try to be as fair as possible. We set up a system where we try to make sure that one innocent person isn't convicted at the cost of 9 guilty people going free. But sometimes people are still convicted wrongly. Right? It still happens. Or they make a plea bargain only because they thought they were not going to be successful. And this is a big problem. But the general way in which we construct things is you don't go to prison unless it is proved beyond a reasonable doubt, with you not having to say anything, where you are represented by a lawyer, and where a jury of 12 people unanimously agrees, right? And the result is that we find not guilty many people who, under other circumstances, might have gotten convicted and convicted unfairly. Any questions? I love this. I really think this is one of the most incredible things ever created. That the only way you can get convicted of a crime, leaving aside the kind of ways that don't always work just right now, the only way you can get convicted of a crime is if the government proves it beyond a reasonable doubt, and 12 people like you get to make the decision as to whether you're guilty or not. It's amazing. It really is. It's an amazing system. Is it perfect? Absolutely not. Right? There are people convicted who shouldn't be convicted. There are plea bargains that should never be made. I had another case in which a plea bargain was made, and I got the court to reverse it, right? And say, no, the plea bargain wasn't right. And then it went back down to trial, the guy got convicted again. Or got convicted this time. But, you know, I think it's such an incredible system that ordinary people get to decide on freedom versus prison, guilt or not guilty. Remember, not innocent, not guilty, not proved guilty. I think this is incredible. All right, let's take a little bit of a break, and then I want to talk to you about the adversary system and the jury system, which go together. The adversary system is a little complicated, and it may confuse you a little bit, but I'll do my best to explain it. Fairly common problem in the United States, men acting aggressively towards women. And by the way, not just in the United States, right? Women tend to get treated badly by men. This happens to be my point of view. I don't think men know how to treat women properly. And for a variety of reasons, it's gotten worse. Well, what happens if a woman experiences this very terrible thing and accuses a man of having done this? Well, all of the procedures that I've been talking about apply and more. I didn't give you everything. So one of the things that has to happen is there has to be, if the man says I didn't do it, there has to be a trial. A trial in which the woman has to come in. Remember, she's not accused. She's the accuser. She has to come in and make the argument that man tried to rape me or did rape me. And this is a very, very difficult thing for a woman to do. Why? Because when a woman experiences this, it's terrible. It's shocking. It's psychologically damaging. It can affect the woman for years and years and years for the rest of her life. And all of a sudden, in order to have the man that attacked her go to prison, she has to go to court and sit on the witness stand and testify against the man in a trial. And remember, the man doesn't have to prove anything. He just denies it. Didn't do it. That's it. Doesn't have to say a word. The woman who is the victim has to do the testifying. And there's a very important rule in the Constitution, in the Bill of Rights. It says that if you're accused of a crime, a man, you have the right to confront your accuser. So the woman can't decide not to testify. Why? Because if she's accusing the man gets to confront her. And the man who's accused has a lawyer. And that lawyer, when the woman testifies, gets to cross-examine her. Ask her questions, which are difficult and painful and embarrassing and psychologically damaging. And this is a huge problem. Why? Because a woman gets raped and she decides, I can't do that. I can't go to court. This is too horrible for me to relive, to testify about, to go through all the psychological harm again. I can't do it. So remember, the man goes free unless there's other evidence. Right? Unless it's been proved beyond a reasonable doubt, he goes free. So it's a huge problem. We tried to develop some special rules, but we can't overcome these rules. These are the rules that govern the trial. A second question I was asked, sort of generally speaking, is about morality. Okay? The problem if you let guilty people go free because it hasn't been proved beyond a reasonable doubt, doesn't this affect society? Doesn't society get, we might say, corrupted by this? You have guilty people, people who have done horrible things walking around free. Why? Because it wasn't proved. Right? Well, the answer to that is I don't think the courts can ever make sure that people are moral. I think it has to be in the customs. You know, I once said to a friend of mine, she had a number of sons, and she said, you know, men treat women so badly. I said, you know, you're right about it. She said, they treat women so badly. And I said to her, you know, it's up to you. She said, what are you talking about? I said, you have sons. You need to teach them how to treat women appropriately. Because the courts are never going to be able to do it. It's got to be in the customs. You've got to teach men to treat women properly. Now, we've been having a continuous conversation about this, about customs. I was raised, my mother knew, I was raised, when I am with a woman and I come to a door, I open the door for the woman. Why? It's not because she's too weak, right? It's not because she's less than I am. It's to show respect. Because women play such an important role in society. Look, without women, none of us would be here, okay? A woman has to, okay, a man and a woman have to get together, I get it, right? But the woman bears the child, right? Delivers the child, feeds the child. Women are entitled to respect. There's no law that says I have to open the door. But my mother taught me, you respect women, right? And you can't use the law to replace good customs like that. Okay, so let me talk about the adversary system. Remember I talked about cases and controversies. There's a case that comes up. And the case always presents a problem or a question. Right? Who did what, when, and how? Okay. Now, if I were to ask you how to answer a question, if I asked you a general question, you know, let's say, in what state is the city of Atlanta? And you didn't know about the United States. What would you do? You might guess. But if you really wanted to know the right answer, what would you do? Look it up. Look it up. You would look it up, right? You would investigate. You'd go into Google, right? Or you'd find a map someplace, and you would investigate, right? This is the ordinary way in which we answer questions. We do research. We look into facts. We try to find out the answer. We call this investigation, right? And it's the principal way that you answer questions in ordinary life. The adversary system does not do it that way. Okay? The adversary system doesn't do it that way. It doesn't investigate. In most courts around the world, there is an investigation by somebody in the court that is responsible for getting the information to help find the answer. Right? Somebody collects all the information. It's then presented to people who look at all that information and do their own investigation and then come to an answer. This is the way most courts make decisions. It is not the way the adversary system works. What does it do instead? It decides questions by an argument. By an argument. You have two parties. Right? This is often called the plaintiff in a civil case. This is called the defendant. Or in a criminal case, it would be the government. Right? Two partners. What happens? They fight it out. They fight it out. Right? There is a decision maker. What does the decision maker do? Listen. The decision maker doesn't do an investigation. The decision maker doesn't do a separate inquiry. The decision maker sits there and listens. This party says one thing, this party says another thing. And they fight about it. Right? And in the end, this person who doesn't do, or this group of people, don't do their own investigation. They use what this party has said, this party has said, what this party gives by way of evidence, and what this party gives by evidence, and decides who's right. Isn't that strange? It's very strange. Right? It's very strange. It's a different way of getting an answer. Instead of somebody being responsible for doing an investigation, you have two parties, each of which has an interest in their understanding of things to be accepted. Right? Each one, this one has a very high interest, wants to win. This side has a very high interest, wants to win. Right? And so they argue back and forth, and let somebody make a decision. This party, neutral. This party, this group, does not do a separate investigation. Now, if it's a judge, as it might be, that judge knows the law. And the judge is allowed to do research on the law. But the facts, solely the responsibility of the parties. And this is true even in a criminal matter. The government says, this is what happened. The defendant's lawyer says, no, this is what happened. And they fight about it. That's why it's called adversary. You see, these are adversaries. Now, here's a question. What are they fighting about? I mean, what happened, happened, right? Right? Well, it's not always so simple. Right? And let me show you how sometimes it's not so simple. This is a little theoretical, and you might find this confusing. It's funny, but it's confusing. Now, you have to forgive me because I'm not a good drawer. What's that? A rabbit. Of course, it's a rabbit. A bunny rabbit, right? Okay? I want you to see something that's really interesting. I'm going to draw the exact same line. Okay, I can't do it exactly because I'm not a very good drawer. Right? I'm going to draw the exact same lines. You tell me what you think it is. Absolutely, it's a duck. Which is it? A rabbit or a duck? Same lines. No? Same lines. Is it a rabbit or is it a duck? Okay? Well, it depends on how you look at it. Right? If you look at it like this, rabbit. Duck. By the way, there are other things that would make you understand whether it's a duck. Even this could be a duck. Right? And if you saw some water here, you would say, oh, that's a duck. Right? On the other hand, if I put this here, a carrot, you would say, oh, it's a rabbit. Isn't this interesting? I think this is so interesting. Right? Two people can look at the same thing and see something very different. And it depends on the context in which they see it. It depends on which way they're looking at it, what other things are around it, and that, sort of depending on what you see, you're going to have a very different understanding of what's there. Isn't that interesting? I could give you some examples of this. Maybe I could use the camera. Maybe I'll rig it up for tomorrow and I'll show you how important this can be. The context in which you see things has a huge impact on what you see. Now, this is really important because which is the better way of thinking about life? Is it that there is an answer that an investigator can find, which is the right answer? Or do we need to think about the different ways of looking at things to find the answer? This is very interesting. Most legal systems say the best way to find out the answer is to appoint someone who will do an investigation and find the answer. The American legal system says answers are not like that. Answers depend upon context, and an investigator often doesn't notice the context. An investigator might be prejudiced by his or her own understanding of things. If you let the parties argue it out, who have all the incentive to do the best job they can, right? You are more likely to get to the right answer. That's the difference between the adversary system and the investigative system. It's more complicated than that, but that's a good way of distinguishing. The investigative system says the best way to get the answer, let somebody do research into the facts as well as the law. The adversary system, the best way to get the answer is let the two parties that have the greatest interest make the best argument they can about how things should be understood. And it's not simple. Which is the better way of getting an answer? Right? Which is the better way of getting an answer? As I said, I think people's natural tendency is to go do research, right? To investigate. Well, the American legal system does not work. Right? So what you have in every case, whether it's criminal or civil, two parties, each arguing about what happened. And the argument is not about the facts. It's an argument about how you understand the facts. What the right context is. Is it a duck or is it a rabbit? Right? Is it a breach of the contract or is it not a breach of the contract? And each party gets to make the best argument they can for their understanding. This is the key to the adversary system. My view, you know my view, it's a beautiful system. Now, one of the reasons that's so beautiful is that we have, in this context, something called cross-examination. Now, this exists in investigative systems too, but in America, it is a high art. Somebody once said, his name was Wigmore, okay? cross-examination was the most effective engine for the discovery of truth that was ever invented by humankind. What does it comprise? So the plaintiff wants to put on evidence. It calls a witness. The witness gives testimony. This is what I saw. When the witness is done saying, this is what I saw, the lawyer for the other side gets up and says, I have some questions for you, and proceeds to examine the witness for the other side about all the ways in which their testimony was perhaps defective or wrong. Anybody ever seen the movie My Cousin Vinny? Oh, if you want to see great cross-examination, it's a very funny movie. There's a great cross-examination because at one point, the prosecution calls a witness. And the prosecution, the government says, what did you see? I saw two boys go into a house, right? Go into a house or a store, right? And about 10 minutes later, they came back up, right? And later on, they found people dead in that store, right? And that testimony was given in order to prove that these men, she didn't see them kill him, see anyone kill anybody, but saw them go in, and then saw them come out, right? In 10 minutes, she said, 10 minutes. Right? But the cross-examining lawyer said, well, let me ask you some questions. What time of day was this? She said, early in the morning. He said, did you just get up? Yes, I was making my breakfast. When you got up, did you put on your glasses? She said, well, no, I don't put on my glasses. He says to her, do me a favor, take off your glasses. So she did. He stood over. How many fingers do I have? She couldn't answer the question. Couldn't see him. Then, he said to her, now you said this was only about 10 minutes, right? And she said, yes. And he said, well, in 10 minutes, it couldn't have been the case that people went in, came out, and then other people came in and went out, right? And she said, right. It was too short a time. I would have noticed in that short period of time whether there were, people going in and out. He said, was it really 10 minutes? She said, oh yeah, well, it's about 10 minutes. He said, what were you doing during this 10 minutes? She said, I was making my breakfast. What did you have for breakfast? He says. She said, I had grits. Grits are a meal that people eat in the South. I had grits. He says, ordinary grits? She said, yes, ordinary grits. He says, I have an understanding that it takes about 20 minutes to cook grits. Are your grits special grits that you did it in only 10 minutes? She says, well, he said, are your grits miraculous grits that develop in 10 minutes rather than 20 minutes? She says, well, were they ordinary grits or were they spectacular grits? Oh, you mean they show up? And she goes, no, they were ordinary grits. So your grits took 20 minutes, right? And she said, yes. So it wasn't 10 minutes, it was 20 minutes. She says, you're right. I didn't think of that, right? What he did is he proved that although she wasn't lying, she just didn't remember clearly. And of course, she couldn't see very clearly. She was embarrassed to admit this, right? And nobody ever thought in the government to ask her whether she had on her glasses or not. He proved by cross-examination that her testimony was not persuasive, right? Remember, his client had to be proved guilty beyond a reasonable doubt. Oh, there was all kinds of doubt now in the case. You see, cross-examination is a way in which skillful lawyers can find problems in the testimony that causes them, instead of it being a rabbit, to be a duck, for you to understand what happened in a different way. She wasn't lying. She wasn't making things up. She just hadn't thought clearly about what exactly had happened. Cross-examination is so powerful, right? And it can make people look really sick. I mean, really, not persuasive at all. I've had the opportunity to do this on a couple of occasions. I will tell you that it doesn't always work. Sometimes you try to cross-examine somebody and you can't make any headway. But sometimes you can prove that people lied, or that they misremember, or that they misunderstand themselves. Right? It doesn't have to be that they're wrong. But when you're able to do this through cross-examination, it takes a long time to learn how to do this. Right? It is one of the most satisfying, thrilling things imaginable. Why? Because after a while, this is going to sound really bad, they're in your control. You know how to get from them the information that will help your client rather than the other side. It's an amazing process. The people who do, I once tried a case with a guy who was one of the greatest trial lawyers in America. And watching him work with witnesses was astonishing. It was astonishing. He could crack jokes. He could say, well, now wait a minute. Let me ask you about this, right? And he would be all over the courtroom. It was astonishing to watch. And remember, often there is a jury. And the jurors are like you, right? And they listen. And they don't do an investigation themselves. They are just neutral. They listen, and they go, that's really interesting. You see, they now look at things in a different way. If you just let them do their own investigation, they would have gone and interviewed that woman. The woman would have said, I saw those boys walk in, and then 10 minutes later, I saw them walk out, right? That's what they would have learned. But because we're in the adversary system in the way we are, that woman's testimony, which she felt really honest about, right, was proved not to be persuasive. This is what's so incredible about the adversary system. It's not that you necessarily prove somebody is lying, although sometimes they are. Right? It's that you show the trier of fact, the judge or the jury, that this testimony is not reliable. That's what you're trying to do. Now, there are many other things you do in cross-examination. It's really wonderful to do. It is hard, really hard. I mean, it's very difficult to do well. But when you get to do it, and it goes well, oh my gosh, it's so much fun. I mean, it really is. I once had a cross-examination that went so well. I mean, so well. And it was a very public case. They were in the courtroom, there were hundreds of people. And they were on my side. They all wanted my side to win, right? And I got done with the cross-examination, and the judge banged his gavel and said, I'm going to take a short break. I need to go to the bathroom, right? He did take a short break, and he left. And I got mobbed by everybody in the courtroom. I thought they were going to put me on their shoulders and carry me out of the courtroom. It was so much fun, right? It was really a great thing. Okay. How much time do I have here? I'm now going to talk a little bit more about juries. Okay? This isn't a complete description of the adversary system, but it gives you an idea about the adversary system. The adversary system is a really different way of investigating matters. You don't appoint somebody to investigate You let the parties develop the facts, bring in what facts they want, and attack the facts of the other side to have them understood in a new, different way. Tomorrow, if I can, I'll try to show you another great example of kind of how the facts are sometimes not what you think they are, right? You look at something, you say, aha, I understand that. And then you see a different context. And you say, oh, that's not what I thought. And then you see another context. Oh, now it's something really good. It turns a duck into a rabbit, or a rabbit into a duck. Now, and I'll show you this. Okay, let's talk about juries. Now, in some of these cases, the group that's going to make the decision about what really happened, what's been proved and what isn't proved, is a jury. A jury, as I've told you now several times, is you. Ordinary citizens who are called on one or another occasions to come and serve on a jury. By the way, you might be called to serve on a state jury. You might be called to serve on a federal jury. Or you could be on both. Okay? Ordinary citizens. People say this is so crazy. Right? Why would you let ordinary citizens decide legal matters? They don't. What they decide are factual matters. They are the people who hear the evidence of what happened. Not the legal significance of what happened, not what the law requires, right? But rather what happened. And when they're doing this, they are subject to very strict rules. They don't get to hear everything or anything. They don't get to hear whatever the lawyers want to put in front of them. We have very careful rules about who they are, what they can do, what they may hear, the sequence in which things happen, and the like. And that's what I'm going to show you now. So I want to teach you a little bit about what it's like to be a juror. And this will help you understand the juries are not quite what they sound like. So what happens? As I said, at some point in your life, you might get a notice from the government saying you're requested to show up at a certain courthouse on a certain day because you may be on the jury. Right? So on a particular day, you go to the courthouse. What are you going to find there? A lot of other people like you. Right? A lot of other people like you. They also got a notice. They were required to come to the courthouse. And you all sit around together until somebody comes and says, the following people, chosen at random, should now come into the courtroom to maybe serve on the jury. These people are called the near men. This is from the Latin. It means people who have come. People who have come. They're called the near men. They go into the courtroom. Usually about 25 or 30 at a time, right? 25 or 30 at a time. They become the near men. The next thing that happens is that they get questioned. They get questioned usually now by the judge, but sometimes by the lawyers. This is a process we call voir dire. This is Latin, or this is, I'm sorry, French legal term. Anybody speak French? Voir dire. So voir dire in French means to mean. This means that, right? But it literally means to see, speak. To see, speak, right? These veneermen sit in the courtroom, and the lawyers and or the judge asks them questions. So the lawyers get to have an understanding of who these people are. The most important thing is, do they have an open mind? Right? Or do they have prejudice? Do they assume the person is guilty? Or do they recognize that the person might not be guilty? Do they have negative feelings against certain kinds of people? Right? So in the South, it was always a big problem when there was an African American who was accused of a crime. If you had all white jurors, there was a fear that the white jurors would assume the person was guilty solely because he or she was African American. Right? During voir dire, you try to find prejudice, reasons that somebody shouldn't be allowed to participate because they will not allow for a fair trial. And anybody who has any kind of bias that's exposed is immediately excused. Right? Immediately excused. In addition, both sides, remember there are always two sides, both sides have what they are called peremptory rights. Each side gets to exclude a few people. Just don't think that person's going to be a good person. I'll throw them out. Right? They don't get a lot of these challenges, but you get a few. So anybody who's shown that bias, immediately excused. And then you, as a lawyer for one of the parties, can excuse certain of the other jurors. It's called a peremptory challenge. Right? By the way, nobody knows who's challenged which juror. Why? Because the rest of the jury may be unhappy with you. They don't know whether you did it or somebody else did it. Right? Eventually, the goal is to find 12, in the case of a criminal trial, 12 acceptable people who have no bias and who have made it through this process of peremptory challenges. Peremptory challenges. So this is really, sort of a process for weeding out people you think will not give a fair trial. What happens next? After those people are agreed upon, the judge talks to them as a group. And the judge gives a really nice speech. If you ever have a chance to see this, it's really great. The judge will always say the following. What you're about to do is one of the most important things you can do as an American citizen. Right? What you're about to do is decide people's rights. This is a great honor. Now, some people go, I'd rather be going to work, right? Right. By the way, if you're called for jury duty, your employer cannot fire you or cannot come after you for any complaint, right? Because this is an important role that you serve as an American. So you're on the jury, and the judge will give you, you're about to do something really important. Then the judge will explain the process so that the jurors have an understanding of what they're going to do. One of the things the judge will say is, you are going to find the facts. I am going to tell you about the law. I'm not going to tell you about the facts. That's your job. I will tell you what the law requires. That's my job. By the way, some cases, there are no juries. Why? Somebody says, I don't want a jury. You get a choice. You don't want a jury, you don't get a jury. Right? Now, the other side might want a jury, in a civil case. So it gets complicated. But in a criminal case, if you don't want a jury, you want the judge to decide, that's fine. No jury. Okay? So the judge will say to the jury, you're about to do something really important. Here's what you're going to do, and here's how the trial goes. The next thing that happens is that the lawyers make an opening statement. the opening statement. It's an opening presentation of the case by each side as to what they expect to prove or won't be proved by the other side. Lawyers are not allowed to argue during opening statement. It has to be just a presentation of what you're going to prove. The lawyers follow this rule all the time? No. They try to find ways to argue, even when they're only supposed to be making statements of what they're going to prove. But the general rule is you're only supposed to say what evidence you are going to present. Now, this is actually an interesting part of the trial. I'll just give you a couple of examples of this. One thing I've learned a long time ago as a trial lawyer is if I tell the jury I'm going to prove something, even if it's insignificant and I don't prove it, they get really mad. Really mad. He said he was going to prove this. He didn't prove it. They hold it against him, right? And this is a really important thing for me. If you promise the jury you're going to prove a fact, you better prove it. And sometimes what happens during trial is very unexpected. So when you're making your opening statement to the jury, you've got to be really careful. You don't promise something where you don't deliver. You need to prove what it is you say you're going to prove. So sometimes when you do your opening statement, you don't include everything you think you're going to be able to prove, because you may find in the course of trial that something goes in a way you don't expect. You got to be really careful. This also, of course, means that the jury only gets to hear a short summary of the evidence, not all the detail. It's a kind of introduction. In addition, the judge will then say to the jury, what the lawyers are saying to you is not evidence. Do not rely upon what a lawyer will tell you. You've got to hear it yourself in the course of the trial. What the lawyers say to you is a summary of what they think they'll be able to prove. It is not evidence. Do not rely on it. The judge will say that. The next thing that happens is that the evidence begins. Evidence begins. So here's the evidence. And it goes in order. First, the plaintiff, the person who brought the lawsuit, or the government in a criminal case, will present its evidence. Then the defendant, whether it's a criminal defendant or a civil defendant, will present its evidence. And each side gets to cross-examine the other side during the presentation of the evidence. So if I'm a plaintiff, I call as a witness. My first witness testifies. The defendant's lawyer then gets to cross-examine before I can present the other evidence. Okay? No evidence is presented without the other side having a chance to attack the evidence. It's adversary all the time. Now, evidence is really important. These are the witnesses, the documents, and whatever else you have that shows something that happened. But the jury doesn't get to hear everything. We have very strict rules about what the jury is permitted to hear. Those rules were developed over hundreds of years based on thinking about what's reliable and what's not reliable. So we have something we call hearsay. Do you know what hearsay is? Yeah, you hear about it all the time. Okay, here's the technical definition. Hearsay is something somebody said outside of court. So, if you have a witness on the witness stand, the witness says, you know, I heard John say this 2 weeks ago. Does not. Why? It's not reliable. To make it reliable, you need John to come in and say what he said. If this witness is saying, John said the following, it's not reliable. Why? Because it's not John. The person that is making the statement about, saying something has to be the person testifying. The witness can say, I said this, but the witness can't say, John said this. We call this hearsay. Now, there are all kinds of exceptions. There are all kinds of cases in which you would permit it. There's one that's very easy. If John is sitting in the courtroom as the other party, you can say, that guy John said something, right? But if John is not a party, is somebody else, let's say it's the party's brother-in-law, you can't testify. There are all kinds of special rules. The point is, the evidence is not just anything. The evidence is very, very restricted to those things that people have found to be reliable over time. Here's an interesting example. If you look in the Constitution, you will find at the end of the Constitution, I think it's Article 6, I might not be right, I think it's Article 6, right, which says, if you're going to be accused of treason against the United States, you cannot be convicted unless you have at least 2 eyewitnesses. You need to have certain kinds of proof because treason is such a terrible thing to accuse somebody of. Only certain kinds of proof will be sufficient. You've got to have eyewitnesses, 2 people who saw you do it, whatever it is. It was treason. Okay? Now, in an ordinary case, it's not so restricted. But we have rules about what's permissible and what's not. So you see, the jury is very carefully chosen, is helped by the lawyers, but only to some extent. The evidence that the jury may hear is very restricted to those things that are reliable. I'm going to come back to that in a second. And then there's more that happens in the trial. Let me just say one thing about reliable. So, think about this treason rule. Only eyewitnesses. Are eyewitnesses reliable? Yeah, this is an interesting problem. People think, like my lady that I was telling you, think they see things that they don't see. If you see a traffic accident out on the road, and there are a number of people standing around who saw the cars crash, if you ask 10 people what happened, you will get at least 4 or 5 different answers. It's one of the really interesting things that eyewitnesses are not reliable, right? So why does the Constitution say you need eyewitnesses? Are they reliable? Answer, well, they're not very reliable, but they're more reliable than other things. People say, well, what about a document? What about a writing? Something that gives the evidence. Who wrote the writing? Person. Was the person telling the truth? Did the person actually see what it is that they were writing about? Is that person reliable? You see, eyewitnesses are maybe not so reliable. But they're more reliable than lots of other types of evidence. That's why the Constitution does what it does. We are having a big fight about this in the United States now, about whether eyewitnesses should be trusted. I always say they're not trustworthy, but they're more trustworthy than other types of evidence. Right? No evidence is perfect, right? So you try through the rules of evidence to get those things that are most reliable. So an eyewitness, right, cannot testify about what he heard somebody else say. He can only testify about what he said or what really happened in the moment. This is kind of how we work through the system. And it's very, very, very carefully done. After the evidence is presented, the lawyers make a closing argument. Now they're allowed to argue. Ladies and gentlemen of the jury, you've heard the evidence. Here's what the evidence shows you. The evidence shows you that on the night of November 4th, so-and-so broke into the house of so-and-so. I mean, this is what happens, right? Very dramatic, right? You want to convince the jury that everything that they heard means that my side should win. Right? That's what you do. But you're still not done. After that, the judge instructs the jury. Right? Instructs the jury. Ladies and gentlemen of the jury, you've heard the evidence. It's up to you to decide how this should be. But let me tell you what the law requires. So the judge teaches the jury about what the law provides. Not what the facts are, but what the law provides. After that, the jury goes and deliberates. And in a criminal case, remember I told you, they have to agree, unanimous, as to what happens. But you're still not done. They come back up. They tell the judge what their verdict is. They're still not done. The judge gets to question them about their verdict. It's called polling the jury. Do you all agree that this is the case? Do you all agree that that is the case? So on and so forth. You're still not done. The judge can overrule the jury. Now, let's be careful. In a civil case, the judge cannot say, I think so-and-so wins. In a criminal case, the judge can't say, I know the jury found him not guilty, but he's guilty. Can't do that. But the judge can throw it out and decide to do it all over again. If the judge doesn't think it's fair. You're still not. You can appeal. The appellate court cannot say he's not guilty. I'm sorry, he is guilty. The appellate court can say he's not guilty, or can say I think it has to be tried again. Right? These are the protections that exist in a jury trial. People look at this and they say that's crazy. How are ordinary people going to be able to make a decision? But it's part of a long process in which the jury plays a very specific role. The jury, having been carefully selected, listens to evidence that we regard as reliable and decides the facts under the instructions of the judge. So, in summary, what I would say is, we have this adversary system. The adversary system allows a neutral decision maker to listen to the sides argue about what happened and how it should be understood. Often that's decided by a jury, but the jury decides it pursuant to this process, which ensures to a great extent that they only rely on certain kinds of evidence that's reliable and decide only the facts subject to the instructions of the judge, who can then reconsider it and make them do it all over again if he doesn't or she doesn't think that the right result was reached. By the way, talking about criminal defendants, I kind of stumbled over this. A criminal defendant might be found guilty. I said this before, but I didn't make it clear. Might be found guilty by the jury. The judge can throw it out. But if the jury decides not guilty, the judge cannot say he's guilty. Remember, we always tilt things to the criminal defendant, giving the criminal defendant every opportunity. Okay, we covered a lot.